Good morning, students. So today we are going to discuss about the remaining functions of promoters under the formation of company. Okay, so in the previous class we discussed about the different functions, like some of the functions of promoter. So I told you that some of the functions of promoters are like identification of business opportunity. Under that, under that I told you that the business opportunity has to be identified in a proper manner, and you should see that if it is technically and economically feasible. So after that I discussed about feasibility study. So under feasibility study we discussed different concepts like technical feasibility, financial feasibility, and economic feasibility. So today we are going to discuss about the remaining functions of promoter. So what are the remaining functions of promoter? So the third function of promoter is name approval. So, having decided to launch a company, so a promoter he carries out all the activities relating to the formation of a business organization. So, the promoter he will have to select the name for the business organization on which it is working, or for which organization he is working. So he's like he has to select a name for that particular organization, and what he has to do is like he has to submit an application to the registrar of companies of the state in which the registrar of office of the company is situated for the approval. So what he has to do in order to get a name to the organization or for an organization is, it's like he has to submit an application to the registrar of the company. So to whom or what kind of registrar is like he has to be he has to be the registrar of the companies of the state in which the registered office of the company is to be situated. So you will have to submit an application to the registrar of companies of the state in which the registered office of the company is situated. So ಎಲ್ಲಿ ರಿಜಿಸ್ಟರ್ಡ್ ಆಫೀಸ್ ಸಿಚುವೇಟೆಡ್ ಆಗಿದೆ, ಸೊ ಆ ಸ್ಟೇಟ್ದು ರಿಜಿಸ್ಟ್ರಾರ್ ಆಫ್ ಕಂಪನೀಸ್ಗೆ ಏನು ಮಾಡಬೇಕಾಗುತ್ತೆ, ಅವನು ಅಪ್ಲಿಕೇಶನ್ನ ಕೊಡಬೇಕಾಗುತ್ತೆ. ಸೊ ದ ಪ್ರಪೋಸ್ಡ್ ನೇಮ್ ಮೇ ಬಿ ಅಪ್ರೂವ್ಡ್ ಇಫ್ ಇಟ್ ಈಸ್ ನಾಟ್ ಕನ್ಸಿಡರ್ಡ್ undesirable. The proposed name may be considered or approved if it is not considered undesirable. So sometimes there are chances that some other company exists with the same name or very similar name as it is preferred is by you, like just like how it is preferred by you. Sometimes there are chances like the other company exists with the same name or a similar name, or the preferred name yes, a preferred name is misleading, say to suggest that a company is in a particular business when it is not true. In such cases the proposed name is not accepted, but some alternative or alternate name may be approved. So I told you that so in some cases like there are chances that the company will use the name of a business organization which already exists. Yes, so it may happen that another company exists with the same name or very similar name, or the preferred name is misleading. So ಒಂದು ಏನು ನೇಮ್ ಹೆಸರು ಕೊಟ್ಟಿದ್ದೀರಿ ಅದು ಬೇರೆ ಕಂಪನಿಗಿರುತ್ತೆ, ಸೇಮ್ ನೇಮ್ ಬೇರೆ ಕಂಪನಿಗಿರುತ್ತೆ, ಅಥವಾ ಸಿಮಿಲರ್ is same alla but similar kind, or preferred name when the what name which is preferred is misleading. ಕೆಲವೊಮ್ಮೆ ಏನಾಗುತ್ತೆ, ಏನು ಹೆಸರನ್ನು ನೀವು ಕೊಟ್ಟಿದ್ದೀರಿ, there are chances that it may be misleading, ಅದು ಮಿಸ್ಲೀಡಿಂಗ್ ಆಗೋ ಚಾನ್ಸಸ್ ಇರುತ್ತೆ. Sometimes there are chances that the company is in particular business and it says that it is into some other kind of business organization, that it suggests that a company is in a particular business when it is not true. In such cases the proposed name is not accepted. So in such cases the proposed name is not accepted, but some alternate name may be approved for this reason. Some alternate name may be approved. So three names in order to of their priority is given in the application to the registrar of company. So, like I told you, it's like there are certain criteria in order to select the name. So, it's like three names in order of their priority is given to the given in the application to the registrar of the company. So, and also the pro forma application for the availability of name in form number 1A also may be given. So, it's like you have to specify three names according to your priority, like 1, 2, 3 ಅಂತ ಹೇಳಿ priority ಕೊಡಬೇಕಾಗುತ್ತೆ. So according to the priority, what the register of the company does is, if it is, or if that particular name is not or been already used by some other organization, then they give you an approval to use that particular name for the business organization. For that reason, what you have to do is, like, you have to give at least three names according to the priority. So the next concept is fixing up signatories to the memorandum of association. Fixing up signatories to the memorandum of association. So the promoter, you have to decide about the members who are signing the memorandum of association. Okay, so the usually it's like the one who signs the memorandum of association are called as the first directors of the company. So promoter, what he has to do is, like, he will have to decide like who will sign the memorandum of association. So memorandum of association is the important document, first and foremost important document required for the formation of a business organization. So promoter will decide like who will, or which member will sign the memorandum of association is. So usually the people signing the memorandum of association are also the first director of the company. So this is also already told. So a written consent to take up the qualification shares in the company is very necessary from the first directors, that is the one who signs the memorandum of association. So ಯಾರು memorandum of association sign ಮಾಡ್ತಾರೆ, ಯಾರು ಮೆಮೊರಾಂಡಮ್ ಆಫ್ ಅಸೋಸಿಯೇಷನ್ ಸೈನ್ ಮಾಡ್ತಾರೆ, ಸೊ ದೇ ಶುಡ್ ಗಿವ್ ಅ ರಿಟರ್ನ್ ಕನ್ಸೆಂಟ್ ಟು ಟೇಕ್ ಅಪ್ ದಿ ಕ್ವಾಲಿಫೈಡ್ ಶೇರ್ಸ್ ಇನ್ ದಿ ಕಂಪನಿ. ದೇ ಶುಡ್ ಟೇಕ್ ಅಪ್, ಆರ್ ದೇ ಶುಡ್ ಟೇಕ್ ಅಪ್, give a consent letter saying that they are ready to take the qualification shares of the company. So the next concept is appointment of professional. So when coming to your appointment of professional, it's like certain professionals such as mercantile bankers and auditors are appointed by the promoters to assist them in the preparation of necessary documents which are required to be with the registrar of the company. So in order to register the business of the business organization, it's like the person who is a promoter has to have different kinds of documents which are really important for the commencement of the business organization as well as to run the business organization. So for that reason, what it does is he appoints mercantile banker and also auditors will be appointed by the promoter to assist the promoter in the preparation of necessary documents which are required to be with the registrar of the company. So the name and addresses of the shareholders and the number of shares allotted to each is submitted to the registrar in the statement called a return of allotment. A name and the addresses of the shareholders as well as the number of shares allotted to each shareholders is submitted to the registrar in the statement called return of allotment. So what amount of share has been allotted to whom it is allotted and what amount of share is allotted is totally provided in the statement called return of allotment. So the next concept is preparation of necessary documents. So promoter, he takes up steps to prepare certain legal documents which is very important for incorporating or to start the business organization. Okay, so these have to be submitted under the law to the registrar of the company. So the documents which is been prepared by the promoter for the incorporation of the business organization will have to be submitted to the registrar of the companies for the purpose of the registration of the company. So what are those important documents which are required for the company in order to get it registered? So ಒಂದು ಕಂಪನಿ ರಿಜಿಸ್ಟರ್ ಆಗಲಿಕ್ಕೆ ಯಾವುದೆಲ್ಲ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಬೇಕು? So the first one is a memorandum of association. Memorandum of association. So like I told you before, it's like a memorandum of association is the most important document as it defines the objectives of the company. So a memorandum is a document which specifies the objectives of the business organization. It's like each and every objectives of the business organization is being specified or will be specified in the memorandum of association. So those things which are not specified in the memorandum of association, those things which are not specified in the memorandum of association are not supposed to be carried out in the business organization. So ಏನಲ್ಲ objectives ಇದೆ, so ಎಲ್ಲ objectives ಅನ್ನ ಏನು ಮಾಡ್ತಾರೆ, memorandum of association specify ಮಾಡಿರ್ತಾರೆ. So those things which are not specified in the memorandum of association should not be carried out in the business organization. So no company can undertake activities that are not contained in the memorandum of association. So memorandum of association, it contains different clauses. So which are those clauses which memorandum of association contains? So memorandum of association ಅಲ್ಲಿ ಯಾವುದೆಲ್ಲ clauses ಬರುತ್ತೆ? So the first one is name clause. So name clause, it contains the name of the company with which the company will be known. It contains the name of the company. It contains the name of the company with which the company will be known. So which has already been approved by the registrar of companies. It's like the name. So I told you that 3 names will be given to the registrar of the company, and registrar of the company will be selecting one among those 3 names according to the what situation and according to the specifications which is available. So like ಹೇಗಿದೆ, ಯಾವ ಹೆಸರನ್ನ ಸೆಲೆಕ್ಟ್ ಮಾಡ್ಬೋದು, ಆ ಹೆಸರನ್ನ ಯಾರು ರಿಜಿಸ್ಟ್ರಾರ್ ಅವ್ರು ಏನು ಮಾಡ್ತಾನೆ, ಸೆಲೆಕ್ಟ್ ಮಾಡ್ತಾನೆ. ಸೊ ಇಟ್ಸ್ ಲೈಕ್ ಯು ಗಿವ್ him 3 names and he will select one among those 3 which is not already used or which does not spoil the dignity or any problems. Okay, I mean which does not bring any problems or which does not spoil the dignity of the country or emblem or anything. Okay, so it's like I told you, the name clause, it contains the name of the company with which the company will be known. So which has already been approved by the registrar of companies. So the second one is registered office clause. So this clause, it contains the name of state in which the registered office of the company is situated or which is proposed to be situated. So ಯಾವ ಜಾಗದಲ್ಲಿ ನಿಮ್ಮ registered ಅಥವಾ company registered office situate ಆಗುತ್ತೆ. So that is why they said that it contains the name of state in which the registered office of the company is proposed to be situated. So the exact address of the registered office is not required at this stage. So while the incorporation gets done, yes, the exact information or exact, so like I specified, it's like it contains the name of the state in which the registered office of the company is proposed to be situated. So the exact address of the registered office is not required at this stage of incorporation. So incorporation ಆಗುವಾಗ ಅಲ್ಲಿ ಏನು ಕಂಪನಿ ಇದೆ ಅದರ ಎಕ್ಸಾಕ್ಟ್ ಅಡ್ರೆಸ್ ಅನ್ನ ಕೊಡಬೇಕು ಅನ್ನೋ ನೆಸೆಸಿಟಿ ಇಲ್ಲ, ಬಟ್ the exact address has to be specified to the register of the company within 30 days of incorporation of the company. So ಏನು ಕಂಪನಿ ಇದೆ ಅದು ಇನ್ಕಾರ್ಪೊರೇಟ್ ಆಗಿ 30 days ಒಳಗೆ ಏನು ಮಾಡಬೇಕಾಗುತ್ತೆ, ಆ ಕಂಪನಿ ಹೆಸರನ್ನು ಅಲ್ಲಿ ಸ್ಪೆಸಿಫೈ ಅಂದರೆ ಅಡ್ರೆಸ್ಸನ್ನು ಏನು ಮಾಡಬೇಕಾಗುತ್ತೆ, ಅಲ್ಲಿ ಸ್ಪೆಸಿಫೈ ಮಾಡಬೇಕಾಗುತ್ತೆ, ವಿಚ್ ಇಸ್ ವೆರಿ ಇಂಪಾರ್ಟೆಂಟ್. So the third one is objects clause. So this objects clause, it specifies it is an important clause of memorandum of association. Like I told you, memorandum of association, it includes all the objects. So ಏನು objects ಇದೆ ಎಲ್ಲವನ್ನ ಏನು ಮಾಡಿರ್ತಾರೆ, memorandum of association specify ಮಾಡಿರ್ತಾರೆ. So it's like the organization is not supposed to carry out those activity which is not specified in memorandum of association. So this is very important clause of the memorandum. So it defines the purpose for which the company is formed. So ಯಾವ ಕಾರಣಕ್ಕೆ ಕಂಪನಿನ ಫಾರ್ಮ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ ಅನ್ನೋದನ್ನ ಏನು ಮಾಡ್ತಾರೆ, ಅಲ್ಲಿ ಸ್ಪೆಸಿಫೈ ಮಾಡ್ತಾರೆ. ಸೊ ಕಂಪನಿ is not legally entitled to undertake any activity which is beyond the objectives specified in the clause. So clause in specify ಮಾಡಿರ್ತದೆ, clause ಅಲ್ಲಿ ಏನು ಅಬ್ಜೆಕ್ಟಿವ್ಸನ್ನು ಸ್ಪೆಸಿಫೈ ಮಾಡಿರ್ತಾರೆ. ಸೊ ಆ ಅಬ್ಜೆಕ್ಟಿವ್ಸನ್ನು ಬಿಟ್ಟು ಯಾವುದೇ ಕಾರಣಕ್ಕೆ ಬೇರೆ ಆ್ಯಕ್ಟಿವಿಟೀಸನ್ನು ಕಂಪನಿ ಕ್ಯಾರಿ ಔಟ್ ಮಾಡಲಿಕ್ಕೆ ಇಲ್ಲ. So the fourth clause is liability clause. So when coming to liability clause, so this clause limits the liability of the members to the amount unpaid on the shares owned by them. So it's like it specifies the liability. So liability of members of a joint stock company is limited to the extent of capital contributed by them. So ಅವರ ಕ್ಯಾಪಿಟಲ್ ಎಷ್ಟು ಕಾಂಟ್ರಿಬ್ಯೂಷನ್ ಇರುತ್ತೆ ಅಷ್ಟಕ್ಕೆ ಮಾತ್ರ ಅವ್ರು ಲಯಬಲ್ ಆಗಿರುತ್ತೆ ಹೊರತು ಯಾವುದೇ ಕಾರಣಕ್ಕೆ ಅದಕ್ಕಿಂತ ಜಾಸ್ತಿ ಅವರ ಲಯಬಿಲಿಟಿ ಇರೋದಿಲ್ಲ. ಸೊ ಇಟ್ ಲಿಮಿಟ್ಸ್ ದಿ liability of members to the amount unpaid on the shares owned by them. So the fifth clause is capital clause. So this clause, it specifies, it is capital clause. It specifies the maximum capital which a company will be authorized to authorized to raise through issue of shares. So issue of shares in the ಎಷ್ಟು capital ಅನ್ನು raise ಮಾಡಬಹುದು. So the maximum amount of capital that can be raised through issue of shares. So the company or the authorized share capital of a proposed company, the authorized share capital of the proposed company along with its division into the number of shares having a fixed face value is specified in this clause. This clause, it specifies the maximum capital which a company will be authorized to raise through issue of shares. So ಒಂದು ಕಂಪನಿ ಎಷ್ಟು ಕ್ಯಾಪಿಟಲ್ ಅನ್ನು ರೈಸ್ ಮಾಡಬಹುದು is totally specifies the total amount of fund an organization can raise. So the authorized share capital of a proposed company along with its division into the number of shares having a fixed face value is specified in this clause. So the company cannot issue share capital in excess of the amount mentioned in the clause. So a company ಎಷ್ಟು ಕ್ಯಾಪಿಟಲ್ ನ ರೈಸ್ ಮಾಡುತ್ತೆ. So what amount of capital is the company going to raise? ಕಂಪನಿ ಎಷ್ಟು ಕ್ಯಾಪಿಟಲ್ ರೈಸ್ ಮಾಡುತ್ತೆ ಅನ್ನೋದನ್ನು ಸ್ಪೆಸಿಫೈ ಮಾಡಿರಬೇಕಾಗುತ್ತೆ. ಸೊ it's like company has to raise only that particular amount which is been specified. ಸೊ ಅಲ್ಲಿ ಎಷ್ಟು ಸ್ಪೆಸಿಫೈ ಮಾಡಿರ್ತಾರೆ ಅಷ್ಟನ್ನು ಮಾತ್ರ ರೈಸ್ ಮಾಡಬೇಕು ಹೊರತು ಯಾವುದೇ ಕಾರಣಕ್ಕೆ ಅದಕ್ಕಿಂತ ಜಾಸ್ತಿ ಫಂಡ್ಸನ್ನು ರೈಸ್ ಮಾಡಲಿಕ್ಕೆ ಇಲ್ಲ. ಸೊ ಕಂಪನಿ is not supposed to raise any amount which is more than the amount specified in the capital clause. ಸೊ ಕ್ಯಾಪಿಟಲ್ ಕ್ಲಾಸಲ್ಲಿ ಏನು ಸ್ಪೆಸಿಫೈ ಮಾಡಿರ್ತಾರೆ ಅದಕ್ಕಿಂತ ಜಾಸ್ತಿ ಯಾವುದೇ ಕಾರಣಕ್ಕೆ ಮಾಡೋ ಹಾಗೆ ಇಲ್ಲ. Okay, so all these are the different clauses that come under the memorandum of association. So one is name clause, second one is registered office clause, third one is object clause, fourth one is liability clause, and the fifth one is capital clause. So the next concept is like articles of association. So articles of association is the second important document required for the incorporation of the business organization. So articles of association are the rules regarding internal management of the company. They are the rules regarding the internal management of the company. Yes, so these rules are subsidiary to memorandum of association. These rules are subsidiary to memorandum of association and hence should not contradict or exceed any things stated in the memorandum of association. Like I told you, memorandum of association is very important document. That is first and foremost important document. So it's like the organization has to act according to the things which is specified in the memorandum of association. So the rules are subsidiary to memorandum of association. So hence it should not contradict or exceed the limits that is specified in the memorandum of association. So according to section 2 of subsection 5 of the Companies Act of 2013, so articles means article of association of a company as originally framed or as altered from time to time or applied in pursuance of any previous company law or this act. Okay, so the articles of association or articles of the company shall be in respective forms as specified in table F, G, H, I, J in schedule 1 as may be applicable in such company. So it's like if suppose if the organization or a public company it may adopt a table A Yes, which is a model set of articles of association is given in the Companies Act. So table A is a document containing the rules and regulations for the internal management of the company. So if the organization does not have articles of association, then it can have table A. So the next one is consent of a proposed director. Consent of proposed director. So apart from the memorandum of association and articles of association, so a written consent of each person named as a director is required, confirming that they agree to act in that capacity and undertake to buy and pay for qualification shares. So only qualification shares anta irutte. So that the person, in order to be the member of the organization, yes, okay, that is the person, in order to be the director of the business organization, he has to purchase the qualification shares. Yes, so only when he purchases the qualification shares, he can be the director of the business organization. Like I told you that apart from memorandum of association and article of association, a written consent of each person who are named as directors are required for confirming that they agree to act in the capacity and undertake to buy and pay the qualification shares. Those, they have to give a consent saying that they are ready to buy the qualification shares as mentioned in the articles of association. So ಅವರು ಏನು ಮಾಡಬೇಕಾಗುತ್ತೆ, ಅವರು they will be the member, that is the directors. So ಅವರು they will have to give a consent saying that they are ready to act according to the rules and regulations, and they are ready to pay for the qualification shares. So qualification shares ಗೆ ನಾವು ಪೇ ಮಾಡ್ತೀವಿ ಅಂತ ಅವ್ರು ಏನು ಮಾಡಬೇಕಾಗುತ್ತೆ, ಕನ್ಸೆಂಟ್ ಅನ್ನು ಕೊಡಬೇಕಾಗುತ್ತೆ. So the next one is agreement. So agreement, it's like agreement. Sometimes there are chances that the organization may carry out agreement process. So the agreement, if any, which a company proposes to enter with an individual for appointment of its managing director on a whole time, a director or a manager, so is another document which is required to be submitted. So organization it has to appoint a managing director. So organization ಒಬ್ಬ managing director ಬೇಕಾಗುತ್ತೆ. So managing director may be appointed on a whole time or as a whole time director or a manager in is another document. So appointment of the manager or the managing director is another important document which is required to be submitted to the registrar for getting the company registered. So a company should have a managing director. So an appointment given to the managing director should be provided or should be submitted to the register of the companies in order to get the company registered. So company register ಆಗಬೇಕು ಅಂದರೆ ಏನು ಮಾಡಬೇಕಾಗುತ್ತೆ, ಅವರು ಕಂಪನಿದು ಏನು ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಆಗಿರುತ್ತೆ ಮ್ಯಾನೇಜಿಂಗ್ ಡೈರೆಕ್ಟರ್. ಸೊ ಆ ಮ್ಯಾನೇಜಿಂಗ್ ಡೈರೆಕ್ಟರ್ದು ಅಪಾಯಿಂಟ್ಮೆಂಟನ್ನು ಏನು ಮಾಡಬೇಕಾಗತ್ತೆ, ಪ್ರೊವೈಡ್ ಮಾಡಬೇಕಾಗತ್ತೆ. So the next concept is like statutory declaration. So the organization, it has to give a statutory declaration. This is a declaration stating that all the legal requirements pertaining to the register has been complied with, is to be submitted to the registrar with the above mentioned document. So ಏನಾಗಬೇಕು, ಏನು ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಹೇಳಿದೆ, ಮೆಮೊರಾಂಡಮ್ ಆಫ್ ಅಸೋಸಿಯೇಷನ್ ಇರ್ಬೋದು, ಆರ್ಟಿಕಲ್ಸ್ ಆಫ್ ಅಸೋಸಿಯೇಷನ್ ಇರ್ಬೋದು, ಅಗ್ರಿಮೆಂಟ್ ಇರ್ಬೋದು, ಕನ್ಸೆಂಟ್ ಇರ್ಬೋದು. ಸೊ ಆಲ್ ದಿಸ್ ವಿಲ್ ಹ್ಯಾವ್ ಟು ಬಿ brought together, or it will have to be joined together, is attested, and it will have to be provided to the, or it will have to be submitted to the register of the companies. Yes, so a declaration stating that all the legal requirements pertaining to the registrar have to be complied with is to be submitted to the registrar with the above mentioned documents for getting the company registered under the law. So this statement, it can be signed by the advocate of High Court or a Supreme Court, or sometimes it can also be signed by a chartered accountant who is in full-time practice. Okay, so if not a High Court or a Supreme Court judge or a chartered accountant, then a person named in the articles of association as director. So ಯಾರನ್ನ ಆರ್ಟಿಕಲ್ಸ್ ಆಫ್ ಅಸೋಸಿಯೇಷನ್ ಡೈರೆಕ್ಟರ್ ಅಂತ ಸ್ಪೆಸಿಫೈ ಮಾಡಿರ್ತಾರೆ, ಯಾರನ್ನ ಆರ್ಟಿಕಲ್ಸ್ ಆಫ್ ಅಸೋಸಿಯೇಷನ್ ಡೈರೆಕ್ಟರ್ ಅಂತ ಸ್ಪೆಸಿಫೈ ಮಾಡಿರ್ತಾರೆ. ಸೊ ಅವರ ಸಿಗ್ನೇಚರನ್ನು ಕೂಡ ಮಾಡ್ಬೋದು, ಆರ್ ದಿ ಮ್ಯಾನೇಜರ್ ಆಫ್ ದಿ ಸೆಕ್ರೆಟರಿ ಆಫ್ ದಿ ಕಂಪನಿ. ಎಸ್, ಸೊ ಇದರಲ್ಲಿ ಯಾರಾದರೂ ಅದಕ್ಕೆ ಸೈನ್ ಮಾಡಬೇಕಾಗುತ್ತೆ. ಸೊ ದಿಸ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಹ್ಯಾಸ್ ಟು ಬಿ ಸೈನ್ಡ್ ಬೈ ದಿ ಅಡ್ವೊಕೇಟ್ ಆಫ್ ಹೈಕೋರ್ಟ್ ಆರ್ ದಿ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಆರ್ ಅ ಚಾರ್ಟೆಡ್ ಅಕೌಂಟೆಂಟ್ ಆರ್ ಅ ಪರ್ಸನ್, ಐ ಮೀನ್ person named in the articles of association as a director or manager or the secretary of the company can sign the statutory declaration saying that or declaring that all the things required for the incorporation of the register of the company is ಪ್ರೊವೈಡೆಡ್ ಇಯರ್ ಅಂದ್ಕೊಂಡು ಏನು ಬೇಕು ಇದೆಲ್ಲವನ್ನು ಪ್ರೊವೈಡ್ ಮಾಡಿದ್ದಾರೆ ಅನ್ನೋ ಅಂದ್ಕೊಂಡು ಏನು ಮಾಡಬೇಕಾಗತ್ತೆ, ಅಲ್ಲಿ ಟೋಟಲ್ ಆಗಿ ಇನ್ಫಾರ್ಮೇಷನ್ ಅಂದರೆ ಡಿಕ್ಲರೇಷನ್ನ ಕೊಡಬೇಕಾಗುತ್ತೆ. So the next concept is like payment of fees. So once the statutory declaration is provided, so ಅಲ್ಲಿ statutory declaration na provide ಮಾಡಿ ಆದಮೇಲೆ, so the next thing what person, that is a promoter, has to do is like along with what a promoter has to do is like along with the above mentioned documents, necessary fees has to be paid for the registrar of the company along with the above documents, like the documents which I already specified. It's like the necessary fees has to be paid for the registration of the company. So ಏನು ಮಾಡಬೇಕಾಗುತ್ತೆ, ರಿಜಿಸ್ಟ್ರೇಷನ್ಗೆ certain amount of fees ಅನ್ನು ಪೇ ಮಾಡಬೇಕಾಗುತ್ತೆ. ಸೊ ದ ಅಮೌಂಟ್ ಆಫ್ ಸಚ್ ಫೀಸ್ ಶಾಲ್ ಡಿಪೆಂಡ್ ಆನ್ ದಿ ಅಥರೈಸ್ಡ್ ಶೇರ್ ಕ್ಯಾಪಿಟಲ್ ಆಫ್ ದಿ ಕಂಪನಿ. ಸೊ ಎಷ್ಟು ಕ್ಯಾಪಿಟಲ್ನ ರೈಸ್ ಮಾಡ್ತೀರಿ, ಸೊ ವಾಟ್ ಅಮೌಂಟ್ ಆಫ್ ಕ್ಯಾಪಿಟಲ್ ಈಸ್ ಗೋಯಿಂಗ್ ಟು ಬಿ ರೈಸ್ಡ್ ಬೈ ಯು. ಸೊ ನಿಮ್ಮ ಕಂಪನಿ ಎಷ್ಟು ಕ್ಯಾಪಿಟಲ್ನ ರೈಸ್ ಮಾಡುತ್ತೆ ಅದಕ್ಕೆ ತಕ್ಕಂತೆ ಏನಾಗುತ್ತೆ, ಇಲ್ಲಿ ಅಮೌಂಟ್ ಅಥವಾ ಏನು ಫೀ ಇದೆ ಅದು ಕೂಡ ಜಾಸ್ತಿ ಆಗುತ್ತೆ. ಸೊ the work of a promoter is a very difficult task. So promoter, you will have to undertake various activities to get a company registered and get it to the position of commencement of business. So ಒಂದು ಬಿಸ್ನೆಸ್ ಆರ್ಗನೈಸೇಷನನ್ನು ರಿಜಿಸ್ಟ್ರೇಷನ್ ತಲುಪಿಸೋದು ಅಥವಾ ಕಮೆನ್ಸ್ಮೆಂಟಿಗೆ ತಲುಪಿಸೋದು, ಇಟ್ಸ್ ನಾಟ್ ಅ ಈಸಿ ಟಾಸ್ಕ್. ಇಟ್ಸ್ ಲೈಕ್ it is a very difficult and a tedious task. So it's like but they are neither the agents nor the trustees of the company. So they can't be the agents as the company is yet to be incorporated. So they are neither agents nor the trustees of the company. So they can't be the agents as the company is yet to be incorporated. So they just carry out activities required for the incorporation of the business organization. So business organization incorporate ಆಗಲಿಕ್ಕೆ ಏನೆಲ್ಲ ಆ್ಯಕ್ಟಿವಿಟೀಸ್ ಬೇಕು ಅಥವಾ ಏನೆಲ್ಲ ಆ್ಯಕ್ಟಿವಿಟೀಸ್ ಇದೆ ಅದನ್ನೆಲ್ಲ ಏನು ಮಾಡ್ತಾರೆ, ಇಲ್ಲಿ ಯಾರು ಪ್ರಮೋಟರ್ ಇದ್ದಾರೆ ಅವನು ಮಾಡ್ತಾನೆ. ಸೊ ಲೈಕ್ ಐ ಟೋಲ್ಡ್ ಯು, ದೇ ಕಾಂಟ್ ಬಿ ಏಜೆಂಟ್ ಆಸ್ ಅ ಕಂಪನಿ ಈಸ್ ಯೆಟ್ ಟು ಬಿ ಇನ್ಕಾರ್ಪೊರೇಟೆಡ್. ಸೊ therefore they are personally liable for all the contracts which are entered by them. They are personally liable for all the contracts which are which they have which are been entered by them. So the company before its incorporation, in case the same are not ratified by the company later on. Yes, okay. So like I told you, they are personally liable for all the contracts which are entered by them for the company before it's incorporated. So in case the same or not ratify the company. So also the promoter or promoters are not the trustees of the company. It's like ಅವ್ರು ಏನು ಅಗ್ರಿಮೆಂಟ್ ಮಾಡ್ಕೊಂಡಿರ್ತಾರೆ ಅದಕ್ಕೆ ಅವರೇ ರೆಸ್ಪಾನ್ಸಿಬಲ್ ಆಗಿರ್ತಾರೆ. ಸೊ ದ ಪ್ರಮೋಟರ್ಸ್ ದ ಕಂಪನಿ ದಿ ಎಂಜಾಯ್ a very important position with the company, so which they must not misuse. So it's like they can make a profit only if it is disclosed, but like must not make any secret profit. Yes, so it's like they can make a profit only if it is disclosed, but they should not, or they are not supposed to make any secret profit. So in the event of a non-disclosure, the company can spoil, or company can stop the contract and recover the purchase price paid to the promoter. So it can also claim damages for the losses suffered due to the non-disclosure of material information. So likewise, a promoter is not legally entitled to claim the expenses incurred in the promotion of the company. So however, the company may choose to reimburse them for the pre-incorporation expenses. So ಏನು pre-incorporation expenses ಇರುತ್ತೆ ಅದನ್ನ ಕಂಪನಿ ಏನು ಮಾಡುತ್ತೆ, ಇಟ್ ವಿಲ್ reimburse. ಓಕೆ, ಸೊ ಅದು ರೀಪೇ ಮಾಡುತ್ತೆ. ಸೊ ದ ಕಂಪನಿ ಇಟ್ಸ್ ಲೈಕ್ ಮೇ ಆಲ್ಸೋ remunerate the promoters for their efforts by paying a lump sum amount or a commission on the purchase price of the property purchased through them. So the company may also sometimes what it does is like it allot them shares or debentures or give them an option to purchase the securities at the future date. So it's like promotion or promoter is like is not legally entitled to claim the expenses. So he is not legally entitled to claim the expenses what incurred in the promotion of the company. So company ge ಏನು promotion activities ge ಅಮೌಂಟ್ ಎಕ್ಸ್ಪೆನ್ಸಸ್ ಆಗಿರುತ್ತೆ. ಸೊ ಅದಕ್ಕೆ ಯಾವುದೇ ಕಾರಣಕ್ಕೆ ಲೀಗಲಿ ಕ್ಲೇಮ್ ಮಾಡಲಿಕ್ಕೆ ಆಗೋದಿಲ್ಲ. ಬಟ್ ಸ್ಟಿಲ್ ದ ಕಂಪನಿ ವಾಟ್ ಇಟ್ ಡಸ್ ಇಸ್ ಇಟ್ ಪ್ರೊವೈಡ್ಸ್ ರೀಇಂಬರ್ಸ್ಮೆಂಟ್ ಫಾರ್ ದಿ ಎಕ್ಸ್ಪೆನ್ಸಸ್ ವಿಚ್ ಹ್ಯಾಸ್ ಟೇಕನ್ ಪ್ಲೇಸ್ for the incorporation. So company, like I told you, may not remunerate may also remunerate the promoters for their efforts by sometimes what a company does is it pays a lump sum. So ಏನು ಮಾಡುತ್ತೆ, ಕಂಪನಿ ಲಂಪ್ ಸಮ್ ಅನ್ನು ಪೇ ಮಾಡುತ್ತೆ, ಎಸ್, ಇನ್ ಫಾರ್ಮ್ ಆಫ್ ಕಮಿಷನ್ ಆರ್ ಇಟ್ ಹೆಲ್ಪ್ಸ್ ಟು buy the shares, or sometimes it what it does is like it provides certain shares to the promoter. So all this are the different benefits which a promoter gets.